Hey everyone, I'm Jessica Packard with Timeero, and today we're diving into a topic that's been coming up a lot lately for Washington employers, and that's meal and rest break compliance. If you've ever been wondering, what the rules are and how to track breaks the right way, or how to stay out of trouble with costly fines, you are not alone. There's been a ton of confusion around this. So, to help us make sense of it all, I'm joined by Colleen Malmassari, an HR consultant and Washington compliance expert who's helped so many businesses stay compliant and protect their teams. So, Colleen, thank you so much for being here. And I hope I said your last name
You are so on point. Yes, as
right.
we talked before, I married an Italian man, or a man of Italian descent, I should say, and so yes, Malmassari is exactly on point. And thanks for having me, Jessica. As a former financial accountant turned HR professional, it's always a joy where I can combine those two skill sets into a single conversation, like the one that we're discussing today.
Awesome, awesome. Yeah, thanks again for being here. So, before we jump into the details, can you catch us up what's been going on in Washington with specifically, of course, meal and rest break laws?
Yeah. So there was a recent ruling in Washington state that has sparked significant discussions about updated labor rights in our state. I am based in Washington state. So when I say our state, Washington is what I'm referring to. That case was the Androckitis. I also am going to stumble on her last name. So that was the plaintiff. And then versus Virginia Mason Medical Center. And this decision happened late 2024. It was actually in the appeals court when this decision came through in late 2024. And it established that employees are entitled to compensation for all interrupted meal breaks and may be entitled to more than one compensated break per shift. The court held in the appeals court that if employees do not receive a rescheduled, uninterrupted 30-minute meal break, employers must pay employees an additional 30 minutes for each missed meal period. So that's the high level. We'll of course get into it a lot deeper.
Yeah, that's sounds complicated too. Uh, so, who you would say are the most affected by it?
Yeah. This decision impacts employees classified in a non-exempt hourly position, as they are the ones subject to the meal and rest break rules dictated by the Fair Labor Standards Act, or as an acronym for everything, FLSA. And the decision was not isolated to the healthcare industry. It is for all Washington employers. So that's why this is really creating a ripple, is it's not specific to an industry or certain group of employees. It's widespread to all of those who are in an hourly paid position. So as we talk about this, let's talk first, what were the rules in Washington state? And then I can help compare what are now going to be the rules. So previously, non-exempt employees in Washington, they're entitled to a 30-minute meal break for any shift of 5 hours or more, which may be unpaid so long as the employee is left uninterrupted for that full period. And previously, if an employee was required to work through part of their meal break, they would be compensated for the time worked, and hopefully, more likely than not, be relieved for the balance of the missed meal break at a later time in the shift. So that's the previous rules. And so now, as a result of this decision, non-exempt employees receive a fully compensated 30-minute meal break if they work any amount of the time during their designated meal period, and can be eligible for pay for more than one interrupted break per shift. So in this case, the court ruled that when an employee's meal break is interrupted, they perform any kind of work, they are entitled to another 30 minutes of pay as a penalty in addition to the 30 minutes paid for working during their meal break. This penalty pay breaks new ground for Washington state meal period laws and regulations previously didn't authorize penalties. So that's what's really coming new to light now. And then further, this ruling also clarified that if there's a finding for willful failure to pay, the penalty doubles. Therefore, employees could be entitled to as much as 120 minutes of compensation for a single missed 30-minute meal break period.
Yeah.
So as you can see, the numbers can start ticking real quick. So,
yeah, it adds up very fast.
Yes.
So you did touch on, you mentioned healthcare and said other industries, across the state can be hit by it. Could you go into more details, like what specific industries, are usually more prone to get hit by those, laws and fines?
Yeah, absolutely. There are certain industries where the very nature of the operations, such as customer facing, on call, and other types, or even the tone of management lends itself to exposure for being able to meet the meal break rules. So in addition to healthcare, which is what this case is, I also see the nature of the operations in construction, hospitality, and retail being some of the more critical ones. And even in my experience, working in the agricultural and manufacturing sectors, there can be pain points when the crew doesn't get relieved by the correct time in their shift as well there. So I won't say there's any industry that's going to be safe, but there are definitely, as you're saying, there's ones that are their very nature of their operations could be giving them more exposure.
Yeah, and probably because those are mobile teams, right? They're not sitting in an office, so it's hard to track them. So the more, scattered you have your team, the harder it is to keep track and make sure they are taking those breaks.
Absolutely. Yep. Yeah.
All right, so let's talk about where things typically go wrong. So what mistakes do you see employers making most often when it comes to meal and rest breaks?
One of the initial problems that I see is that employers have an employee incorrectly classified as salaried, or I should say exempt is the technical term, and they're paid on a salaried basis. Some employers are incorrectly basing their employees' classifications off of too much overtime, or the earning levels are the only thing that they're looking at, and not also the duties tests that are required by the FLSA. Or another one is that employees are asking for a consistent annual wage. They're technically, their duties don't classify them as exempt, but they want a consistent pay every pay period. And this is mostly applicable to industries where there's seasonality to their operations. Of course, agriculture, retail, hospitality, there can be peak seasons in a lot of those, manufacturing, many of them. So once an employee is classified as exempt, they are they are exempt from the FLSA rules, including meal and rest break periods, not just the exemption from overtime. So when someone's incorrectly classified and they're not getting their meal breaks, that's of course a big problem there. The second most common mistake is not having sufficient systems in place to properly monitor and meet the compliance of the requirements of meal and rest break rules, and I'm referencing both manual and digital systems. I'm not just one or the other, because a lot of the times there's a mix, or depending on the size of the company, there's one preferred over the other.
Yeah.
Yeah.
And so what exactly happened? So let's say, I have an employee and they forgot to take a break. They completely skip it, or, they took a break late. So what happens, and how should a company handle it?
Yeah, that's a really good question. In my experience, this is going to happen. It's inevitable. Luckily, humans, we are not robots. We're not consistent day in and day out of time. So our daily needs and life may impact our workplace, or the operations may shift. So it happens. Hopefully it's infrequent, as employers' processes are structured to observe employees' earned meal breaks. That said, an employer's processes need to address the response when a meal break is interrupted or skipped. So what I see is it's critical for an employer system, manual or automated, identifies that the full 30-minute meal break was observed, so that the employee can be properly compensated. And then the payroll records are the ultimate source of support to defend why an employer did or did not pay an employee during the pay period. And statute of limitations is generally 3 years. So you want to make sure that your reporting, in most cases, your time cards, are clear. And it's important to remember that these rules also apply for employees who work extended shifts, where there may be work more than 10 hours and qualify for a second meal period. So in some cases, there may be a need to track 2 meal periods in a single shift.
Yeah, makes sense.
Yeah.
Okay, so I know we talked about it a little bit at the beginning, but what really happens when a company isn't compliant with break laws? And we're talking about specifically, Washington State.
Yeah, thank you. Yeah. Remember, yeah, we're in Washington. So worst case scenario, there are financial consequences through penalties imposed for the employer violations, and most likely some legal costs. And the more intangible financial cost is lack of trust in your workforce, right? To not be respecting these rules and regulations of their earned benefits. So I won't go too much into that part, because that's harder to quantify. Hopefully, long before an employer gets to that place, they have some internal checks to ensure that the systems are correctly identifying interrupted or missed meal breaks, and/or employees feel safe to timely report those discrepancies on their paychecks. And it is in the employer's best interest to have employees come to them first, instead of those employees feeling like they have to go to outside agencies or legal counsel to get their proper pay. For example, within the 2 months of the Androckitis decision, or two months following that final appeal decision, 7 new cases had been filed in Washington State over missed breaks. So obviously, we as employers, as a collective, need to be very mindful of this, because it is on the minds of employees.
Yeah, that's for sure. And do you have any examples, you came across of companies that actually got hit with fines over this?
Yeah, well, I don't yet, and hopefully won't, but don't yet have any direct involvement with companies that have received fines or lawsuits because of this updated meal break rules. However, I have recently been working with clients on other wage and hour claims that have been brought up through the Washington State Department of Labor and Industries, who have then been representing their current or former employees in their claims. One of the claims was specific to overtime, and another in regards to the Washington paid sick leave accrual. In both scenarios, the payroll reports for the past 3 years didn't adequately reflect how the employee was being paid. So the interpretation was left up to the employee. Specifically in the overtime claim, we were able to provide sufficient support sufficient support to show the employee was sufficiently paid, and the claim was closed without findings, which was an awesome win for that client. And then on the paid sick leave claim, we're still waiting to hear back from the review of the documents we've submitted. Both of these claims took a significant amount of time and energy from the business owners throughout the summer and early fall. So definitely not the best use of resources for a small to medium-sized business to have to go through these types of claims. And I just want to add one additional point coming back to the Androckitis decision. That awarded nearly $100 million in damages for up to 8,400 employees that was involved in that class action. And that's about $11,000 and then some per person in the class. So definitely can start to add up pretty quickly.
Yeah, and it's like the snowball effect, right?
Yeah.
You have one small slip up here and it adds up. And if you have 1, 5, 10 employees, 20 employees, it just adds up so fast. And when you get hit hard, right?
Yeah. And it can be innocent too. Like I was talking to one other client earlier this spring who were like, we have employees, when we look at our records, they're clocking in at 28 minutes. They're coming back to shift before the full 30 minutes. And the rule is clear. If it's not a full 30 minutes, that they could be at fault. So, right, just it can be innocent too. It doesn't have to be malicious.
Yeah, no, that is true. So let's talk about solutions. We talked about, all the issues with it and, financial issues to the company. So let's talk about the solutions. How can employers protect themselves and make all the break and rest tracking easier for them?
Yes. So that's the goal, right? Let's be proactive versus reactive. Let's have some processes in place to help mitigate our risk. It's definitely a better strategy for employers from a retention and a financial perspective to be proactive. Because the calculation of payroll is no longer simple, especially in Washington State where there are expanded wage and hour rules. I'm a firm believer in leveraging digital tools to help automate the review for errors and or meeting compliance requirements. We just have so much data coming at us these days that we make mistakes. And so having those digital tools to help us not make those mistakes is a best practice. However, it is important to remember that the employer still has the fiduciary responsibility to understand and monitor the systems that they put into place to perform the steps on behalf of the employer. Anytime we're putting a technology into place, we should be thinking of them as a teammate, as an employee that needs to have some oversight. And so interestingly, the failure by Virginia Mason in this case was to ensure that their digital systems was operating in alignment with the rules and regulations, and which was one of the reasons that they owed employees for damages and meal breaks. The timekeeping system required employees to attest each shift as to whether they received a meal period. And as part of the self-reporting process, Virginia Mason's timekeeping system automatically deducted 30 minutes of pay for meal period eligible shifts, but reversed the deduction when employees reported a non-compliant meal period. Thereby, they were paying employees for time worked during meal periods. But and that's good. But then in the plaintiff in this case was then saying that they claimed that paying employees only for time worked was insufficient under the Washington state law. And that's why she and the class action sought damages for time worked plus 30 minutes of penalty pay plus the double damages on the underpaid penalty pay. Yeah. So the trial court and Washington State Court of Appeals, they both agreed with the plaintiff and the class action. So that's where it became a newer part. Their system was designed what was, I think, happening standard in business, but it wasn't truly in alignment with the rules and regulations, which is what was clarified in both the trial court and the appeals court.
Yeah. And what you said, even though you're leveraging tools, you still need the human oversight. And, it's very, very clear how tricky compliance can be. And it's definitely something that we are very focused here at Timeero. So with our app, employers can, track both paid and unpaid breaks right now. It's very simple, very clear, very straightforward, and user-friendly too, because I think that needs to be, something in place, not only for the admin side, but also for the employee side. Got to be something that is easy for them to buy in, to adopt. And yeah, so we have that in place, but drum rolls, we also have coming soon. So we are to make sure other states, have the best opportunities to stay compliant, to have all the tools. So we are building out, it's coming up soon, the Washington state and also other states, because right now we have only for California, but multi-state meal and rest break policy compliance, so you can customize it. So basically, employees will be able to sign at the end of their shifts that, oh yes, I did take the break. If not, why they didn't, and also have an attestation with them, so that it's just an extra layer to help them with compliance. And I think at the end of the day, it's all about giving these teams a little bit of peace of mind, so they know you have a tool that is tracking the breaks. It's easy for them to go back if they ever got audited. They can go back and check the paperwork, the timesheet, the responses, and also to be on top of what's working now, because it's not, no matter what tool you're using, it's not set one day and forget it. You have to constantly be checking it every day, every week, set up a cadence, so you are not, just hit by a lawsuit at the end of the day.
So important.
Yeah. All right. So if you, it's a lot we talked about. Yeah. I'm gonna take a water break. Yes. So if you had to boil it down to, let's say, a checklist, so what are the top 3 to 5 things that employers in Washington specifically should be doing right now to stay compliant?
Yeah. We're already starting to talk about some of those things, right? Through our conversations so far. Top of my list, review and update your break policies. So if you're not aware of this decision, it's time to open up your handbook, your policies, review them, revise where needed, so that your policies are reflecting the new ruling, and then clearly communicate them regarding or clearly communicate to your employees regarding the entitlement to paid breaks and the procedures for meal breaks. Should they be available wherever employees look for policies, either in the handbooks or training materials, but they need to be shared in whatever platform is common for your workplace culture. So that's one. Two, analyze your systems and documentation used. So do the current systems meet the new standards? How are you testing that? And again, when I'm saying systems, I'm talking about manual or digital or a combination of both. And then what documentation is in place to support interrupted meal breaks and waived meal breaks? And then third, train supervisors and managers. They are your frontline staff. They're the ones most likely receiving the first line of communication on these. So implementing this ruling requires that supervisors and managers are adequately trained. They must understand the importance of respecting meal breaks and the implications, easier thought than said, implications to the employer and to the employees of this ruling. And then the training for the supervisory personnel should focus on the need to facilitate uninterrupted break times. And then, supervisors play the role in managing workloads and effectively to prevent interruptions during meal breaks. So all those three things are at the top of my list.
Yeah, this is awesome. That's a great, summary of the most important things. So yeah, Colleen and our team, we put together Washington break compliance checklist with everything that we talked about. This, most important steps that you can start applying out to your business. So it's completely free. Just, go to the link below. There will be a link below here in this video that you can just go ahead and, just download it for you. But I just wanted to say, Colleen, thank you so much. This was awesome. This was very, very helpful. Thank you for taking the time to chat with me. But if anyone wants to connect with you and learn a little bit more about what you do, how can they find you?
Oh, Jessica, I want to extend gratitude for the collaboration to make this podcast happen. It's been fun getting to know you and work with you. And then for any of the listeners that want to receive direct consultation on this topic or any other people initiatives, I can be found on my LinkedIn profile, listed under my name, Colleen Malmassari, or at my website, Back 40 Advisors, and the 40 is a 40, and advisors is plural. So Back 40 Advisors. And on my website, you can also find other resources and sign up for my quarterly newsletter that I call the Almanac.
Awesome. Perfect. Yeah, I'll make sure to link all your information below too, so everybody has access to it. Well, thank you so much again. And for everyone watching it, don't forget to grab your free checklist. And if you're ready to take compliance to your next level, just go ahead and try Timeero for free. We have free trial. And just try for yourself and see how much easier it is to stay compliant with meal and rest breaks. Yeah, Colleen, thank you so much again. Thanks everyone, and see you guys next time.